You're back with us tonight on In Focus. Justice Minister Ronald Lamola has withdrawn his court challenge to Deputy Chief Justice Raymond Zondo's application for an extension of the Commission of Inquiry into state capture. The Commission has requested a 3-month extension until the end of the year to complete its final report. The Minister had raised concerns about the cost implications of an extension and asked the court to cap the Commission's future costs at 15 million rand. For more on this, I'm joined by News 24 legal journalist Karyn Maughn. Karyn, good to have you with us tonight. Does this mean now the Commission has got a blank check? They can just go on as long as they wish, or is this matter of cost being addressed?
Well, you know, the case is going to be heard in the Gauteng High Court in Pretoria tomorrow morning. It's going to be a virtual hearing. I'm sure that this issue may be raised, but at this point, you know, the application by the inquiry is not opposed. So, you know, there's no palpable opposition to it, having seen the Department of Correctional Services, whilst not opposing it, wanting certain conditions for that extension. I think what is very obvious is that for the first time, on the 5th extension of the inquiry, we have seen the Justice Department coming forward and raising objections, you know, as you said before, seeking 6 weeks rather than 3 months, raising issues around the cost, also saying that DCJ Raymond Zondo had failed to produce a plan about how he would have the report completed in 90 days. So it's really the first indication that we have of the Justice Department raising these kind of objections in the way that they have. Then subsequently, you know, just a few hours, you know, a day after that application was in fact launched, withdrawing it on the basis that the kind of issues that they had raised, they'd received assurances from the inquiry that they would be addressed in court tomorrow. But certainly a very, very powerful indicator that not all is well in the relationship between the inquiry and government. Yeah,
what has changed, you know? Of course, this is reminiscent of the ANC withdrawing its court challenge of the IEC. But of course, this is government. The government initially went, okay, we're going to challenge this. And now they are withdrawing that. What have they learned that is new? What has changed in this process?
You know, I think from speaking to people behind the scenes, there was some of the information that was conveyed in that court paper, especially around the issue of the expenses, interactions with National Treasury, the reasons the Treasury may have given for not providing the funding that was requested by the department, certain assertions that were made about the budget by the Justice Department appear to be contested by some of the people, you know, with knowledge of this issue, and there seems to be a bit of uncertainty as to whether the Justice Department correctly conveyed, you know, the picture when it came to the budget issue. This is not something new, though. We know that the former Finance Minister Tito Mboweni at one stage saying that, you know, he didn't believe the Treasury would be willing to keep funding the inquiry. This issue of the cost, it is the most expensive commission of inquiry in South African history. Has been routinely used by its critics as one of the bases to contend that, you know, to undermine its credibility and its use within South African society. That being said, DCJ Raymond Zondo has repeatedly stated that the kind of court applications, for example, brought by the National Prosecuting Authority Asset Forfeiture Unit to recover hundreds of millions of rands, have more than justified the expense of the commission, and that the kind of information and evidence that it has been able to provide to the investigating directorate has been invaluable. And certainly when I've spoken to the head of the investigating directorate, Hermione Cronje, she has said very plainly that a lot of the work that they had been doing would not be possible without the assistance and the efforts of the investigators within the inquiry. That all being said, it is truly remarkable that in that context we see Justice Minister Ronald Lamola empowering his Director General, Dr. Mashabane, to go on record and to really effectively provide the people criticizing the inquiry with a slew of ammunition about its operations and its leadership. And certainly that is quite an extraordinary thing. And I don't think that just because this matter has been withdrawn, those kind of tensions are gone. And certainly there will be a lot of questions asked about the assertions that were made by the Justice Department in those court papers.
Yeah. Is this government saying, okay, get this over and done with now, get to the finality of this, we can no longer afford this, or is there something else that's going on?
I think there's understandable frustration. I mean, the inquiry was originally supposed to take 6 months, and it was focused in a very narrow ambit on the issues that the then Public Protector Thuli Madonsela had been unable to get answers from, particularly from then Head of State Jacob Zuma. And so, it was really focused on this issue of Eskom, in particular, the Gupta's involvement there, the Tegeta oil contract, the coal contracts, etc. When the terms of reference were released by government under the leadership of Jacob Zuma, it ballooned into a massive investigation which, looked at corruption in all arms of the state, and really went far beyond what the initial public protector investigation had looked at. But that being said, at some point you have to draw a line in the sand and say, okay, this is what we're focusing on, and we're going to complete this work and get it done. And I think that, there's been ongoing issues with funding. We know that at one stage the investigators for the inquiry hadn't been paid for 6 months. We know that the people keeping the lights on, doing the recording and the broadcasting were not being paid over time. That was a long-running issue, and I'm at this point not even sure if it has in fact been resolved. So there's been a clear tension there, which is unfortunate because it fundamentally undermines what is essentially intended to be a truth-seeking exercise, but more importantly, one that empowers prosecuting authorities to the prosecuting authority in this country to produce very strongly, evidentially strong cases that get successfully prosecuted in court, and give them the ammunition to seize assets that they believe can be shown to be the proceeds of crime, and recover that money to the fiscus. So, what is happening over the last 2 days with this application, I think is profoundly unfortunate, and I think there needs to be more of an explanation from all the parties involved in this, so that the public isn't left with the distinct impression that they are at each other's throats for reasons that are not necessarily immediately apparent.
Yeah. What is holding up the final report? What are the reasons there? We were led to believe that the chairperson of the commission was, I suppose, writing this report as we were going along. It's not as if he waited for the commission to finish and then say, okay, let me go over this. It's probably 2 rooms now full of documents that he would need to go over in the next couple of days.
Well, apparently, according to the affidavit that he filed in the High Court, he was saying that he had, that certain, groups of people were basically in the process of preparing summaries of the evidence of the 330 witnesses that have been testifying over the last 3 years. And that he'd sort of allocated time for first, second, and third drafts of those evidential summaries, and that he had underestimated the amount of time that would be required for that process. And that in one case, an individual who had been dealing with a very specific issue had fallen ill and was unable to provide the summary in time. So he's very much said that it's a consequence not of poor planning on behalf of him or the commission, but really, an underestimation of the time involved in summarizing, what has been 3 years of testimony from these witnesses. I think the other interesting point for me is that we at this stage, we've heard a lot of murmurings from, amongst other people, the former SSA Director General Arthur Fraser, that, he'd wanted to come and testify at the inquiry. He hasn't given evidence, that there may be applications, we don't know from who, in regards to some of the testimony led. So there's also this possibility that there may be some litigation even prior to the report being released, certainly in terms of those issues about who got to testify and who didn't. So I think that's something that we need to be mindful of, and I think it's also something that could affect this question mark over the funding going forward.
Yeah, and of course that would also bring the question from some quarters to say, well, if this report is going to be challenged anyway, why take so much time? Just put it out there, because we know that it's going to go to the courts with either the former president who never actually showed up at this, or as you put it, Arthur Fraser and many others who are not quite satisfied with how this process went.
I think the inquiry's response would probably be, well, if we wanted to stand up to legal scrutiny, we need to make sure that it is as evidentially solid as possible. There are going to be, and we've DCJ Zondo said this in the past, there are going to be aspects of the inquiry where he may not decide to make findings, and he may refer certain aspects of the investigation to other law enforcement bodies to probe further, because he hasn't been able to get to the bottom of some of the issues. But it's very clear in relation to the evidence that we've seen led, particularly over this last year or so, that there is going to be a huge focus on Transnet, Eskom, the involvement of people like Brian Molefe, Anaj Singh, Machela Koko, and others, who have been, allegedly involved receiving bribes or money from the Guptas, and pivotal players, according to some of the evidence that's been led in the so-called state capture project. Of course, they vociferously deny this and have repeatedly stated that they have been falsely implicated for nefarious purposes. But it's very clear, based on the evidence of particularly those individuals, that they don't accept that they have any liability. And I think that the Commission would want to present a report, certainly in terms of what happened at Transnet, Eskom, and some of the other SOEs, that can result in potential, prosecutions and asset forfeitures going forward, but also is able to stand up to legal scrutiny. If it makes adverse findings against any of those individuals, that they're able to take it to a court, and the court is able to say, well, based on the way the evidence has been presented here, based on the arguments and conjecture, based on the documents, etc., those findings we do believe are sustainable.
Karyn Maughn, thank you for illuminating the situation for us tonight. I appreciate it. Legal journalist at News 24, Karyn Maughn, they're helping us through that conversation.